James, would love if you guys could just go down and give quick introductions and take it from there.
Sure. My name is James Gatto. I'm a partner at Sheppard Mullin, about 1,000-person law firm, which is probably about 900 too many. But the other 100 focus on different aspects of interactive entertainment and blockchain and NFTs. And I head up that group, do a lot of work in the IP space, a lot of the agreements and other regulatory issues from securities, gambling, tax, et cetera. I've been involved in the space since about 2012. One of my clients became general counsel of the Bitcoin Foundation pretty early on and kind of dragged me in, and so I've been having a good time for the last almost 10 years.
Hey everyone, my name is Moish Peltz. I'm a partner at Falcon, Rappaport, and Berkman, where I chair the emerging tech department. My background is intellectual property law, where I've basically been doing that for my whole career. And then I had a buddy, same as Jim, started a Bitcoin mining company in 2014 and dragged me into it. And that was always a side project, working on crypto-related stuff, and didn't really see the intersection between crypto law and intellectual property law really until like the end of last year, turning into this year. And since then, it's been off to the races and almost off my practice.
Yeah, and my name's Jacob Martin. I have a cheeky Twitter handle. It's @TheNFTAttorney. I do a bunch of things, a couple things really well. Everything else, I just kind of am a filter, and I pass it to guys like this. My brother tried to drag me into blockchain as well in 2013 just to buy weed, because that's what he was doing with Bitcoin, just buying weed. And I was like, wow, I don't need weed money right now. But I started working on smart contracts in 2018. I raised some funding for a startup, and while in law school, and then now at this point, I've worked across kind of the whole range of DAOs, NFTs, securities, IP, and I have a solo law firm. It's just me. I'm actually talking to some bigger firms because it's just me. And then, yeah, I'm in some DAOs and other things, so just kind of across the market.
Well, thank you so much for those introductions. Really excited about the hot alpha that you guys are going to give us about law, so just please take it away.
Great. Well, I think, Moish, you're going to start with the little context.
Yeah, so I think all of us on stage here have seen it's been a really interesting year, and I think for me the big theme is maturation of the people, the companies, the people building in the space from much earlier in the year. It was very disorganized, people on Discord servers to, you release a 10,000 PFP project at 0.05 ETH, all of a sudden you got like $2.5 million to figure out what to do with. And all the sorts of basic things like, should we be a company and how do you structure that? Should we have an operating agreement? Should we have inbound IP, like figure out from artists and creators, like how we're getting IP into this project, how we're licensing it out to the end users, all sorts of like independent contract agreements and just operational business type things. Now we're talking more about tokens, like non-fungible tokens leading to fungible tokens, which raise all sorts of securities issues. We're talking about DAOs and project treasuries, and some of it's like the PFP context, some of it's just some like companies building Web3 companies, and so it's really exciting, I think, to see that maturation from earlier in the year where I think people weren't really talking to attorneys or maybe knew they should be but didn't know what questions to ask to I think that's really evolved now where I think there's a lot more intelligent things to talk about and work on.
Yeah, I think one of the great dichotomies is that with the whole concept of blockchain and decentralization is people don't want to have to focus on the law. I think the unfortunate truth is law still applies. And so I think one of the key things we try to do is help companies understand like what law applies and when. And in the context of NFTs, one of the things we talk about a lot, and it came up in the last panel a little bit, is that there's a lot of different models out there for NFTs, right? So you can have outright ownership of the underlying asset. You can have license that's limited to personal non-commercial use. You can have limited commercial use. There's different business models, and there's not really one right or wrong way to structure your NFTs. But one of the things that I want to convey that I think is really important that people aren't focusing on, and for the companies that are building the infrastructure, they don't care about this as much, but for the brands and for content owners that are licensing their IP as part of an NFT, this is a really critical thing, and that is, if you want to impose license terms and restrictions on what someone can do with their NFT, you need a valid license. You need a valid enforceable license. And so just like when someone goes on a website, right, if you just post terms on the bottom of your site, courts typically won't enforce that. That's why we all get these annoying little boxes that pop up and say, I agree to the terms of service, because courts typically require some affirmative acceptance of legal terms for someone to be bound. The problem is, how many of you have bought NFTs and you see there's no license terms that apply, right? You look at the platform terms of service for most of the marketplaces, and a lot of them don't really address license issues, and if they do, it's a one-size-fits-all. It's either A or B, right? It's not any one of the various models that may exist. So one of the things, we represent a lot of the brands that are licensing IP to creators to create NFTs for them based on their brand, but they want to make sure the licenses apply. And so we're starting to see, like OpenSea will put enable you to put a license next to an NFT that says, by buying this NFT, I agree to these license terms. Just like you see in other contexts. And so that's, I think, one big issue on the brand side or the IP owner side that people aren't focusing on that they really need to. And the corollary to that is, even if you do get a valid license from the first buyer, then the question is, how do you make sure that that license is binding on a subsequent purchaser? Because they may or may not have an option to click, I agree. And so there's some different things that we're doing with respect to agreements on that. And I think more importantly, over time, I think we'll see, did I go too long? I think that there's a number of companies out there right now that are trying to develop technology to address this at a platform layer, to work with the minting sites and the marketplaces to embed a layer that facilitates the ability to impose licensing. And so I think that's kind of one big area from the IP perspective that people need to focus on.
Yeah, I think for myself, I would say that I'm very much on the side of decentralization, to the point that, like, with IP concerns, with securities concerns, there comes a moment where, like, the question is, like, how decentralized is the team? How decentralized is the protocol? AKA, is there anything to even sue? Like, is there anyone to sue? Is there anything to sue? And I'm not saying that because I'm looking to sue them. I'm saying that when I approach a project or I'm looking at something being done, I think it's one of the largest considerations right now is, like, can it be sued? Can it be shut down, right? Because if Disney is working with Sheppard Mullin and they're worried about their licensing, that makes a lot of sense. But if CyberKongz does a fair launch out of nowhere from no one, it doesn't matter if it's deemed a security. There's no one to shut down. There's no thing to shut down, right? So Banana could be delisted or make sure that it's not on certain websites. CyberKongz could be pulled off of OpenSea, assuming anyone chose to go all the way to call it a security. But even if they did, it's a decentralized team. There's no one to shut down. There's no thing to shut down. It's Doge, right? It's crypto. It's decentralization. So for myself as a lawyer, the questions and conversations I have with clients a lot, and I mentioned earlier, so, like, I do a couple of things really well because I've got like 4 or 5 years of blockchain experience. I'm only a couple of years into being a lawyer. I'm not an expert in 15 fields of law, but what I know is Web3, and I know how to have the conversation to find out how decentralized is your team. What are your hopes? What are your expectations? Are you trying to license this? Are you trying to protect yourself? Do you want to sue people if they add swastikas, right? If you want to sue somebody for adding a swastika, you're retaining some amount of ownership there, which means you're retaining some amount of hand in the pot, which means, like, you can sue them, but it also means they can sue you, right? Like, there's this tether when you tether yourself to your assets that makes it a centralized ownership of a decentralized asset, right? So a lot of the conversations I have are much more around protocol and framework and structure on these things. And if I have an IP issue, I would work with an IP attorney. If I had a securities issue, I would go to a securities counsel. But I'm identifying a lot of frameworks, and I would say one of my favorite IP situations this year is the funks, CryptoFunk, right? I have a CryptoPunk. I also have a CryptoFunk. It's a flipped CryptoPunk, right?
Do you have the same one?
Yeah.
Okay.
I have the funk of my punk, right?
Okay.
And the thing is, some people really hate CryptoFunks because it's a blatant ripoff of the IP. swapped pixel for pixel sideways. But I like to bring up Warhol just painting a Campbell's soup can, right? Like, you got to realize that there's something about art. Not every not every NFT project is art, and not every project's a collectible. Not every project's a game, right? There's different layers. Like, at some point, we're talking about conceptual art with a flipped CryptoPunk, and the most punk thing you could do would be to piss somebody off. So they created CryptoPunks to piss off CryptoPunks and the rest of the market. And it worked, right? Like, to be fair. So it's a fascinating IP situation where they're delisted from OpenSea, they're relisted on OpenSea. They're delisted from OpenSea, relisted, delisted again, right? That's what CryptoPunks have done. I think it's fascinating, and it's like, the question at some point is, where do lawyers come in and why does it matter? Like, how much legal would Larva Labs spend to shut down a blatant ripoff that's a flipped knockoff, like a ripoff knockoff, right?
Yeah, I think the difference is that if you don't really, if you're copying someone else's IP, you don't care about protecting the IP, right? But if you're a brand, particularly brands, because it's not just about their NFT, it's like they're putting their brand into the NFT or some content, and they're trying to protect not just the NFT, but the brand overall. So I think the answer is different for different companies, right? If you're just throwing out some NFTs and you're ripping someone off, yeah, you don't really care about the legal issues, and that's fine, to a certain extent. But
yeah, I think it's also the thing that's changed this year that I like, and the reason that lawyers have gotten more relevant, I think, is it's the same reason, like, when CryptoPunks cost 10 grand earlier this year, it wouldn't have made sense for someone to start an NFT project and spend 10 grand on legal, because they weren't thinking, why would I spend that much on legal? The whole market is only worth this much. But it's like, as the market has gone up to the point where CryptoPunks are worth $500,000, apes are worth $200,000-300K, people see a $10,000 legal bill as a necessary evil to not F up the project that they're about to put into the wind, right? It's a lot better to pay $1,000 for a consult or $10,000 for a lawyer, whether you follow their advice or not, right? Like, whether you protect or have a license or not, or whether you launch a fungible token off the back of a non-fungible token. I've advised at least 10 companies not to add a banana-style token to their project because they're a centralized team that's doxed. And if a securities implication came down, it would go directly on them, right? Out of those 10 teams I said don't do it, 2 did it. I'm not their lawyer though, right? We had a call, I was paid, we had a legal framework call, and they said, all right, we understand our risks, we're just gonna go do it anyways. But it's been interesting to see as the market's gone up, right? You see the same need for legal and accounting and tax, all of it on this uptrend, whether we're right or wrong, or whether they follow it or not, right? So I've enjoyed seeing that this year.
Yeah, I think an interesting thread between like both of that, and I think I straddle both of these worlds of advising brands that are, maybe Web 2 brands trying to get into the Web 3 space, and then, just like Genesis new Web 3 brands, is like what is the purpose of intellectual property? What is the purpose of securities laws? And like, is there a brand building, brand protecting aspect to that? Is there a regulatory consumer protection aspect to that? And what can we do in the Web3 space that's new? Because this all is new in a way that is going to be a genesis of something new. So I think ultimately, like, where this is trending in 3, 5, 10 years is we're going to need at least tweaks of existing laws to like account for some of these things. But in the meantime, it's like those laws are there. We don't know what all the implications are, but here's what the risks are. Here's how you're going to address them, and here's how you're going to like approach them in like a way where, in 3 to 5 years, you're not surprised that like something insane happened. You knew that risk was coming. You accepted that risk, and you made a decision to go one way or another based on informed advice about that topic.
I think as far as the new law issue, I mean, this kind of always comes up with every new technology is we need new law, and I don't really necessarily agree with that. I think when you look at like NFTs, there's really 2 parts. There's the token part, which is it's just a registry on a blockchain that represents.
Bring your mic up, son. You're just too far from me.
Okay. It's just a representation of ownership of some asset that's recorded on the blockchain. The asset is still the asset, and if that asset's a digital media file, the law that applies to licensing a traditional digital media file that's not recorded, the ownership is not recorded in the blockchain, applies, right? So if you are licensing an NFT and you care about legal issues, you want to ensure that you own the IP rights or have licenses to whatever the content is that's in that file. Otherwise, you're licensing something you don't have rights to, and you subject yourself to lawsuit. And you want to, ideally, as I mentioned earlier, you want to, to the extent there's IP you want to protect, you want to make sure that there's a valid license that kind of goes along with that. And so I think, when you think about it that way, the legal issues are the same as, for the most part, almost any other digital media licensing issue. There can be unique issues with the token, and there can be, there's some brands that have already created IP around their NFT. So like Top Shot, for example, like the format of how they present the moments, right? There's IP around that. So there can be other IP issues beyond just the media file, but I think for the most part, I don't think we need new laws. I think what we need is really more an effective.
What do you think about on the securities side, though, right?
Well,
so like securities laws, at least, right, to protect consumers. I mean, Banana Token is pretty great. Cyberkongs are pretty great. Banana Token's pretty great. It's obviously a security if it was a centralized doxed team where you buy a thing and by doing nothing, you get this yield of this thing going up, right? But like, at what point are we protecting consumers, right? Like, I think, at least with Moish making the tweak comment, I think there's at least room for tweak, right? There's at least room for conversations on the tax side and on the security side. Maybe not so much IP. You might be right. It might be more.
Well, I think even IP, like, there was no internet, and then there was the internet, and that wasn't contemplated by existing IP laws, and we had the DMCA, and that's like not perfect, but it was a tweak, and it seems to be pretty broadly approved. So like, I think that's kind of like, I think as an industry, we need to figure out like what regulations do we want? Like, how do we want to be regulated? What are the laws that we need for our clients?
It's its own book. It's its own book of law, metaverse law. It's gonna be.
Yeah, but like, it doesn't exist. So like.
James doesn't like the metaverse law comment.
Look, I mean, look, just because something is digital, the regular laws still apply for the most part. The thing is that technology always pushes the envelope and the law lags behind. Right. And so there's this uncertainty. Like we've seen, like when everyone was doing ICOs on, traditional, tokens and crypto, the SEC came out with guidance, and they said it's guidance on a framework analysis for digital assets. So you'd think it would cover all types of digital assets, including NFTs. It arguably does, but it's not specific to it, and it really is more like, it raises more questions than answers. And so, a lot of people think because NFTs, represent a unique item that it can't be a security. And there's definitely scenarios where an NFT can be a security. And so that categorical statement that they can't be is not correct. The areas you need to be concerned about from a securities perspective, fractionalization. If you're pooling, you have NFT that represents, shared interest in some item and there's some revenue coming from it, that scenario can raise securities issues. If you're selling NFTs that are designed for use on a platform, not just art. If it's art, you can display it, if there's a current use for it, the likelihood of it being a security, if it's just all you're getting is a right to the art, is pretty low. But if it's an NFT for an object that can be used in a game, and they're pre-selling NFTs to raise funds to build the game, and the platform's not there yet, then you're in the fact scenario that the SEC gets concerned about, that you're raising capital to build something, and people are relying on the builders' efforts, and that could be a security.
Yeah, I think just to jump in and add, like, one thing people tend to forget or not realize when they say an NFT can't be a security or art can't be a security or whatever. The thing he just referenced right there is very specific. Buying an item for a game with a game to come, right? So the first case law in the US on securities is helping a guy buy a field of oranges, right? A huge orange grove that he wants to turn into a country club. And you're buying a plot of the field of oranges, which is a membership unit in the country club in the future, and shared revenue on the success of the country club. Like, that sounds like an NFT fact scenario, right? Like, you're buying a digital piece of land in a thing that doesn't really exist. Then they're gonna build a beautiful thing on this random plot of random land. You're gonna have some kind of shared upside or shared ownership in the thing to come. That's literally the first ever securities fact pattern. It had nothing to do with a token or a share or a paper document or, right? Like, that is securities law. Right. So that is like, that's exactly where I think, we talked about a bunch of IP earlier, but this is the stuff as well, where like, nobody out of us three and nobody I've met is an expert in all things NFTs, because you can't be. There's too many layers. There's too many topics, right? Like, we could have 6 different attorneys from 6 fields say how they think their field of law should be tweaked, right? Because everyone would agree, like, okay, this securities thing should be tweaked. Yeah. Maybe this IP thing should be tweaked, or maybe this part shouldn't. But Disney's contract with clients moving forward absolutely is going to say, we reserve the right to use your image in NFTs. Yeah. Right? You don't. you don't have the right to use your image in NFTs. That's what Disney's going to say. I've already seen contracts from multiple record labels that say, coming in, we control XYZ, bullet point, also anything related to your song, your voice, your image associated with NFTs through this contract, right? Like, so the man coming top down, Web 2 or traditional art, music, entertainment, they're going to top down, go ahead and control as much as they can, which is where I guess I would say, like kind of how Moish referenced earlier, I probably do represent more Web3 native coming into the market types of brands. Whereas like I've advised Hasbro and Christie's and a couple of the bigger ones on very specific Web3 things. But yeah, I'm coming from more of the Web3 side, which is like, okay, this is decentralized. These people have a good intention. They have a good project. But how do we do it legally? Like what can be done? And I would say something, I don't know if you guys have seen, that I helped with 2 different styles of licensing deals this year that I think are really cool. One is with Jenkins the Valet. So they really wanted to do this project where everyone could take their Bored Ape, put it into a book, and then share revenue. That would be pretty much a security, right? So what I did was I talked to them, we worked on a licensing mechanic. So we actually license your ape into the book the same way we would license your ape into a movie or license you as an actor into a movie. And it's an even royalty across anyone who licensed their ape into the book. So X% of book sales, book profits, goes to the apes that were licensed. So it's an IP licensing mechanism instead of buy our NFT, get a share of our book sales, right? And then the second one that I've helped work on that I think is really cool is with Doodles. Doodles have this, it's a great project. I like the Doodles a lot. I've got some Doodles. I'm a bag holder of Doodles. I love them. But they have this thing called the Doodle Bank. And when they originally came to me, they were calling it Doodle DAO. And I was like, well, what is the DAO? Like, are you giving away equity ownership or not? And the answer was like, no, like they weren't giving out equity in their company through a DAO. They explained this community treasury type thing where they would abide by the vote of the people, but it was like they were gonna hold the money basically in a wallet that they controlled. And if the vote was too crazy and it would actually tarnish the brand, they wouldn't do it, right? So they added minor limitations. So it's like Web 2.5, Web 3. It's somewhere in the middle there. And what they've done is, I think traditional brands haven't, well, I mean, traditional brands have had to worry about it, but it's been different. If you wanted to rip off Mickey Mouse and put him on, let's say, bed sheets and sell them on Etsy, Disney's gonna try to stop that. But with NFTs, it's so blatant when you're ripping off a project and selling a derivative project. It's just blatant, it's right there. And so what Doodle Bank offers is for anyone who wants to be inspired by the Doodle's color palette or style or whatever and make a derivative, you can come into the Doodle Bank and propose, here is our proposed derivative. Do we have your blessing, right? And we'll set aside 300 of the 1,000 for minting for Doodles holders, or, right, there's some kind of relationship. And then some of it's public on the offer, like the public proposal, and then some of it's discussed in the back, basically, which is like a revenue split, right? It's like a, come talk to us if you want to do a derivative, and then they might set up a deal, they'll go offer it publicly. That's a pretty cool way to maintain like this brand integrity, right? Bored Apes didn't hold as much control as the Doodles do, but if you read their licensing agreement, they pretty much can shut you down if they don't like it, right? Like there's a bullet point.
Well, it's interesting because they actually have 2 licenses. One was for the Bored Apes and one was for Mutant Apes.
Right.
And they're very different, and you can
They're
see
different.
we
Yeah.
hired an attorney at this point kind of thought
They got
process.
better.
Yeah.
The license got better, yeah.
Yeah. Just one last thing on the securities, just to pick
Yeah.
up on what Jacob said, and I agree with that. So I think the key is that there's a lot of really interesting business models you all are working on, and the thing I would say is that you really, like on the security side, there's anytime there's a revenue share, we see people trying to do like a rewards component. If you buy NFTs, you get a percentage of revenue of subsequent revenues or stuff. Anytime you're doing any kind of revenue share stuff, definitely get that vetted, because that needs to be done right. As Jacob said, if you're structuring something as a royalty as opposed to a pooling of revenues, even though it may just seem like form over substance, legally it makes a difference. So it's not a question if you can't do what you want to do, it's you want to try to do it in a way that minimizes your legal risk. The SEC is ramping up their enforcement staff, and we're going to see another wave of enforcements, just like we saw at the end of the ICO boom. So I think it's worthwhile to, if you're doing something innovative, just spend an hour with an attorney just to understand what the legal issues are, and is what you're doing clearly illegal? Is it clearly legal? or more often than not, it's somewhere in the gray, and depending on your risk tolerance, and often attorneys can make recommendations on tweaking your business model to make it safer. And that's really, none of us, there's no attorneys right now that can give guaranteed answers on a lot of the questions that are out there that you guys are facing, but we can help mitigate the risk. And if there's, an agency that comes after you and you've worked with, lawyers who are competent, you've got an opinion, and it's a close call, you're not likely to have a big problem. You're going to have to maybe stop what you're doing or change it if they decide, or fight it. Just because the SEC says something is security doesn't mean it is. We see Ripple's fighting them now, and hopefully we'll get some further clarity. But in the interim, I'd say it's really primarily about managing risk and just getting the facts vetted and understanding what the risks are and how to mitigate them.
Yeah, I think one thing that we're going to end up doing, I don't know if it'll be me or all three of us or just several others, but you got to realize we're going to see like $10 billion of NFT transactions this year, and we'll probably see $100 billion 2 years from now between gaming, art, collectibles, right? I personally think my first use case when I raised back in the day was to put wills and trusts on chain, so to automate asset distribution when you die, right? I think we're going to head towards a world where smart contracts are in play for pretty much most things. Deeds on houses, deeds on cars, asset distribution at death, ticketing to get to the Lakers game, ticketing to get in here, no need to stand in line, NFT, ping the system, come inside, right? This is where I see blockchain going. The problem that we're seeing right now, like with the current infrastructure bill, which should be about building roads, is that they add a bunch of random crypto things in there that are really restrictive and really problems. So, the 100 attorneys in the country right now that are actively working on this space, I'll say 100 might even be generous at this point. I know 20 that are competent, like on some field related to NFTs, maybe 30. It would take longer to figure out who else. But I'm doing my best to never use the word narc, and I've talked to Punk6529 a little bit about this. I don't want to narc, but at the same time, if we don't hold hands with legislators as they're trying to legislate in the US on crypto, they're just gonna wreck what we're doing. They don't understand what's happening. They don't understand decentralization. They don't understand the implications of what is being built and what's coming. So I haven't done anything yet narc-ish, but the House Financial Services Committee on Digital Assets reached out to me, right? I'm working with Charles Kolstad, a premier tax attorney, on the NFT tax guide that I put together. Again, not because I want you to get wrecked by taxes, it's just because I know you're going to get wrecked by taxes because you don't know how to take money out of your MetaMask through anything other than Coinbase, and that's 1099, right? You're going to get wrecked on taxes. So I work with Charles Kolstad and some others on the NFT tax guide, which is an NFT and comes with ZenLedger software and whatever. But the thing about Charles is he's quoted 8 times in the infrastructure bill on crypto tax regulation specifically. And working with people like Charles on helping advise on taxable situations, right? If I put in 10 ETH and then transact a bunch of times, there's no reason they should tax every movement of my ETH or ETH to this or ETH to that, right? I don't think. That's a personal thing, right? It makes sense I put 10 ETH in. If I take 500 ETH out, sure, tax me on the full hit of the 500 ETH. But instead, they tax you all the way up, right? Australia doesn't. Australia taxes you on whatever comes out, not every in-between movement. So some countries are more forward than others. Some don't tax it at all. That's insane. We're never going to get there. But there's ways to help on the security side, on the financial assets, on is it a collectible, is it long-term cap gains, right? This is interesting, and I think the three of us here, like I mentioned, we're among the few attorneys that can even have the conversation right now and not tell you you're crazy for using words like staking and yielding and this here and Solana and ETH and gaming and future, whatever, right? So I don't have a final answer there, and I don't intend to be a narc. But there may come a world where I show up dressed just like this to Congress with O'Shiny wearing his bucket hat, and we help the best we can. I hope that's helpful.
We're running out of time here pretty soon. One other issue I just want to flag that we're seeing kind of a growing trend is with NFTs and promotions and other things that are done is people are kind of skirting the sweepstakes laws and kind of crossing over into gambling pretty frequently. So it's fine to do, there's certain types of sweepstakes you can do with NFTs, but you still have to comply with sweepstakes laws, which in the US is pretty much every state has their own laws. But that's an area I think we're also seeing. We're seeing a lot of that in games. Just like with traditional games, there's loot boxes and other chance-based mechanics. We're seeing a lot of things like that with NFTs and blockchain-based games and others. And that's another area where I think the caution bell should ring, because there's two ways to get in trouble there. One is the regulators, and they haven't done anything. In the U.S., there's these laws called the Gambling Loss Recovery Statutes. If people lose money in a gambling scenario that's illegal, they can sue to get their money back. And all the lawsuits out there right now against game companies are by plaintiffs' attorneys trying to sue to get, kind of class action lawsuits. And so they're the ones that are actually out there trying to, cause havoc for people. So there's a couple of things you can do to mitigate that, but just wanted to flag that as a last issue for me.
Yeah, and I think that's one thing, the giveaways, the sweepstakes laws, people are doing lots of giveaways, and if you're just giving people ETH, it seems like it's a lot easier to control and mitigate some of the risk there, but you start giving away really big hard assets, it gets interesting, and that leads into the idea of litigation, right? And I know Jacob and I have already worked together on several litigation projects, and this is something that you're thinking about, going forward, mitigating this risk. The SEC right now is litigating, the Ripple case for something that happened in 2017, project forward another 5 years, like what are those NFT litigation cases going to look like 5 years from now? And then, what can you do in the meantime to mitigate a lot of this ultimately is like litigation risk, either regulatory or, plaintiffs' attorneys and things like that. And that's where you really want to have good terms of service, a good project, be able to predict and expect these things and not be reactive but proactive.
Really well said, guys. Thank you so much. So give a round of applause for Jacob, Moish, and James. Thank you guys so much.